Frank. Sorry, Jonathan. Before we start, just a reminder to all of our viewers, please go to therealdeal.com and subscribe if you don't already. That's how we can afford to bring you these free webinars every Monday and Wednesday at 5 o'clock. So we have a lot to talk about. And Luis, I want to start with you. I wonder if you could give us just a quick rundown of the kind of, for each of you, the kind of tenants you typically represent, just so our viewers know what kind of background you're coming from.
Sure, happy to do that. Let me start, Eric, by saying I wanted to thank you, and I wanted to thank The Real Deal for having John and I on this. It's an opportunity to speak to the real estate community post-COVID, and I certainly want to thank The Real Deal for its leadership and for being able to bring the industry together and let people know about current events generally in New York. That's most important to me and to I think most of my clients, but across the country as well. So I wanted to thank you very much for that.
Well, I appreciate your joining us. And so are you typically representing commercial tenants or commercial landlords?
I typically represent owners and developers and hotelers and not-for-profits that are operating properties. So it really runs the gamut, but I do represent some commercial tenants, but I think we talked about this briefly the other day, you and John and I. In this post-COVID world, I think I would probably be clear that I would not be representing commercial tenants that are making defenses to their failure to pay rent.
We're going to get into that.
I would say so. I would say that, well, I also represent both landlords and tenants, borrowers and lenders, buyers and sellers. And I think that what Louise's point is that some of the defenses that are raised to rent payments under the leases are a bit of a stretch. And so those things that you can't, you can't say with a straight face, she's not going to bring those in and as a defense to a summary proceeding, and I wouldn't either. By the same token, we actually have a couple of leases, and I wouldn't say it's by far the norm, it's the other way around. But we do have a couple of leases which actually have protection for the tenants in a circumstance like the pandemic. I think it's unusual, and I would say 95 to 98% of all leases don't provide for that, but there are a couple that do. I think it's come as a surprise to some landlords, but I think for the most part, the obligation to pay rent is a continuing obligation, even in these circumstances.
So are your professional lives basically dominated by non-payment of rent cases at the moment?
No. It's an issue.
Our professional lives are dominated by people's problems, of which there are an innumerable amount, and they come in all shapes, sizes, and colors.
That's for sure.
They're not all COVID related at this point?
I would say this, John, I think that you're 100% right. There can be instances, and you may have a clause in your office right now that we are going to end up in a litigation on, but few and far between that are going to allow a commercial tenant to step out of their obligations post-COVID. I think there can be, and it could have been contemplated, although seemingly wouldn't have been contemplated a lot, not unlike what happened with 9/11, where terrorist issues and clauses with respect to terrorism became very prevalent post 9/11. I think we're likely to see that here as well.
But at the time, when Lower Manhattan was largely shut down for months, right, what was the resolution of those cases?
Not impossibility of performance or frustration of purpose. So I think we can take that as sort of the what's likely to occur in the litigations that are going to take place. Jonathan and I do have different practices. I mean, John, is in the transactional arena and does deals, and I'm a litigator. So, this is a time and a circumstance where it's difficult to be a litigator because the courts have ostensibly been closed. They just reopened just a tiny bit, but not really. And most disputes, whatever they involve, have to be resolved, if they can be, outside of the judicial arena, which makes it difficult.
So nothing has really been resolved yet as far as this, do you have to pay rent during a pandemic issue, right? There have been no settlements, very few decisions, is that right?
Yeah, I think there are very few decisions, although there are a number of litigations that have been commenced, including in federal court, to argue impossibility of performance, frustration of purpose.
Position of purpose.
Right, I'm not paying, et cetera, et cetera. But there have been a couple of cases that have been instructive. I know we talked the other day about a bankruptcy case, but that was in Chicago, Illinois, where the bankruptcy court seemed to adopt the idea of a reduction in rent as a result of a reduction in the space because of the shutdown, or reduction in use of the space. But there's a magistrate who just decided a case in New York, applying New York law, where he said unequivocally not, this is not an excuse for non-payment of rent. The fact that it's impacted you financially does not provide a defense to the obligation that you had to pay money that you were required to pay into a stipulation the court was administering, and said, you're in default. That's it.
I'm gonna ask you each to do a very quick explainer for our audience. Jonathan, if you could just explain what that frustration of purpose argument is, and then maybe Luis, you can explain.
I mean, the frustration of purpose is that, I was leasing the space to occupy it as my office because of the stay-at-home order, or because of the I can't really use the office space for what was intended, or take a restaurant space because of the orders and not being able to serve indoors. I can only serve outdoors. Therefore, my purpose for which restaurant has been frustrated, and therefore I ought to be excused from my rent. And I think that the courts have said the frustration of purpose is really more nuanced in terms of the circumstances where it would come up. And if you applied that to every circumstance today by virtue of the pandemic, then no one would pay rent. And obviously the result of that would be that there would be a sea of defaults throughout the city, and not just New York. It would be New York, it would be Atlanta, it would be California, San Francisco, LA, and so on and so forth. And I think that's just not the rule today.
Right, Luis, why doesn't frustration of purpose resonate for you as an argument? I mean, it sounds like if you can't open your restaurant and let diners in, that's a frustration of purpose, just from a layman's interpretation.
If part of what you negotiated for in your contract, and you're a restaurateur, and you put in the contract, in the lease with the landlord, in the event I'm unable to get a certificate of occupancy in order to occupy the premises by such and such date, and if by that date I don't have it, my lease is over, well, then you'd have a really good argument under your contract. But if you didn't reserve those rights, the doctrine is narrowly construed, okay? And they're gonna look at first, is there something that applies to this? Because if there isn't something that applies, contracts require, and the world requires, certainty in terms of entering into contracts to be able to rely upon what it is the parties agreed to. If the parties didn't address something because it wasn't something that was contemplated, to now argue, I'm not obligated to pay my rent to my landlord, who's a third party and had nothing to do with this. It's not as if the owner did something that resulted in the shutdown of this business. The owner's at much in the line of fire from the government directives as are the tenants here, right?
So
And by the way, it's not one particular building that's singled out because of some particular problem. For example, if building had a series of health code violations and the building was shut down for the health code violations, then you have a serious argument that you have interruption of services because the landlord failed to provide the services that were required to be provided under the terms of the lease. And so one, you'd have a rent abatement for the interruption of services from whatever the time period that the lease provided, you were entitled to that abatement. And if it went on for an extended period of time, there might even be a termination right in the lease that says if the interruption of services continues for more than 30 to 60 days, that the tenant has the right to terminate the lease. Those are things that are contractually bargained for. And I think that's what Louise is going to, where fine, if I made that business deal and therefore this building was affected in that way and the landlord didn't do something that it should have done, then that's my right. That's what I bargained for. But this is a circumstance where none of the landlords did anything wrong. There was a pandemic that kind of came down that affected all of us, some extent, some to a lesser, some to a greater extent. And then when the stay-at-home order went into effect, in fact, it wasn't that they were shutting down the buildings. It was simply saying people other than essential personnel were being ordered to stay at home in order to prevent the spread of the pandemic. So
Right.
again, the landlord didn't do anything wrong. The building is operational. You could come in, you could turn on the air conditioning, you could turn on the heat. You'd have somebody at the security desk letting you up and down. But the issue was people were being ordered for things outside normal operations to not go there, not because it wasn't available, but because the government decided that in order to protect the populace at large, people should stay at home.
Right. So generally, I'm guessing that when you write these contracts, you are putting in clauses that protects your clients from harm if they did nothing wrong. Right. I see. It seems like almost.
Well, I mean, there are circumstances. For example, if you have a fire in the building, the landlord may have done nothing wrong, but if in fact the tenant didn't get access to his premises, then there would be a provision with casualty that would say there's an abatement of rent in that circumstance. There are things about interruption of services where it's landlord's fault. There's generally a rent abatement. Where there's not the landlord's fault, it's a cause beyond the landlord's control. Then usually there's a longer time period before there's a rent abatement that flows from that. And I think the problem is that this circumstance is not one that falls into those categories. The pandemic is not one where they're not providing the services. The services are there and available. It's just people can't take part of them because they've been subject to stay-at-home orders.
Yeah. Right. By the way, what if the restaurant sets the fire?
The restaurant sets the fire, they go to jail for arson.
It could have been an accident. It could be a grease fire.
By the way, then Louise can really help them.
It'd be going to a criminal attorney, not John or I.
Oh, what if you just let the grease get out of control and you have a grease fire, the restaurant burns down, then can you get out of your rent that way, or is that your own fault?
Well, see, now you're getting into this whole thing. What if? That's exactly it. It's always fact specific. Mm-hmm. But what you're hearing, I think, pretty uniformly from John and I is that the argument that just because this occurred, I don't have to pay my rent, neither one of us see as a viable argument.
Right. So what about force majeure?
Right. No, but it's the same thing. The argument is, something happened outside of my control and I shouldn't have to pay as a result. And force majeure, again, there are instances many times where in part of a negotiation, you say, in the event of force majeure, happens. To the extent that that's not something that's carved out or preserved, you're going to have to show something a lot more than just, hey, I was on the Times Square area and I expected a lot of foot traffic and now I'm not getting foot traffic.
Yeah, it's funny, that sounds like a ridiculous argument, but we are actually seeing that argument in some cases right now. And yes, I don't know if either of you represent.
Well, I think you're seeing a lot of arguments that you might otherwise think of as ridiculous, only because people are struggling. I mean, listen, there are difficult times out there, and if your business was all predicated on a certain thing, I mean, take a look at Madison Square Garden. There are not that many concerts going on. There are not that many sporting events going on. That was exactly. So that was not part of their business plan. Their business plan was not to not have concerts and not have hockey games and not have basketball games. So we're all struggling with that. I mean, one of the things that Louise and I have talked about is that, if you could look back at 9/11 when you had the issue of the terrorism risk and how do people deal with that. And I think that's the issue that we're going to have to deal with going forward. The pandemic having become so real, we're going to have to deal with it in leases going forward in one way or another. And I think what happened with terrorism risk insurance was that it was so expensive that you couldn't actually place it because no one could underwrite to that effect. So what happened was that there was TRIA, which is the Terrorism Risk Reinsurance Act, which was in effect passed so that the government was a backstop. And therefore, underwriters could write the insurance because they knew that beyond a certain point, the government was stepping in to backstop their obligation. And so what it was a very difficult challenge in terms of negotiating leases became easier because people said, well, I'll buy terrorist insurance as long as the cost is not, within a commercially reasonable, or it's not double what it was last year, or whatever and with TRIA, that became doable. The thought was maybe you could do something similar with the pandemic. Thus far, the government's been preoccupied with doing other things and hasn't been able to do that.
Right. We've also seen, in the case of flood insurance, the government has stepped in, provided flood insurance. And also, you couldn't build a nuclear plant at one time because insurance companies wouldn't cover because the possibility of an accident, the damages would have been too great. The government stepped in and provided insurance for that. So those are two models we might see used in the future once we get through the stimulus.
You know what, Eric, John just said something, and I think, it's important to talk about. 100% people are hurting and everything else, and everyone feels for circumstances that were unanticipated and that are now really disastrous. That said, for my clients, and I would think a lot of John's as well, most bargain for certain things that they are now not getting as a result of these laws. I mean, there's a contract between two parties. It says XYZ, and now the government steps in, the city council steps in and says, hey, those personal guarantees that you thought you had, Mr. Owner, that protected you in the event that there was a default? We're going to just say for right now, there's nothing you can do about it. All of those guarantees are off the table. And to the extent that you're talking about a one asset entity, and the only asset is the lease, they can walk away. And it doesn't matter whether the owner put in
Louise,
$5 million build out or anything else.
By the way, why don't you talk about that? Because the nature of the executive order is kind of more limited than that. And I think people don't necessarily have the full perspective on what that executive order does and what it covers and what period it covers. So maybe that would be something that would be useful for you to speak to.
So just to clarify, we have the governor's executive orders on one hand, and we have that city council bill that was passed and signed by Mayor Bill de Blasio in New York City that allowed basically small restaurants and other small businesses to exit their leases early and not have the landlord go after their personal assets. That's the personal liability clause you're talking about, right? And only during the pandemic period. So
for a particular part of the pandemic period.
Right. So believe it or not, I didn't hear that much complaining from the real estate community about that bill. There was some argument about the government interfering with contracts, and that was true, but no one really made a huge fuss about it.
Well, they couldn't go into court.
That's true. There is a lawsuit.
They couldn't make a fuss. They couldn't sue anybody.
That's exactly right. You could only complain. That's why we're on your show. So we could, but you know what? What's interesting is actually there was a Suffolk County District Court judge who actually took issue both with the fact that the judiciary was issuing directives, and he said, you don't have this unconstitutional, you don't have the right to do this. And by the way, he then took exception with the executive order saying, in order to do what you're doing, you have to have specific statutes that you're amending, you have to do this, you have to do that, and you're limited to 30 days, and your executive order goes longer than that. So as far as I'm concerned, that's also out of the box. So there's not nobody that said anything, but as you say, there haven't been a lot of judicial decisions, that's for sure.
That was one of the craziest rulings I've seen, because we're talking about a district judge. Honestly, I didn't even know this court existed, but there's a court in Suffolk and Nassau County only.
By the way, don't tell that to the leaders of Suffolk County.
This little judge slapped down the top judge in,
Don't diss Suffolk County. Right?
Yeah, don't diss. Now you got to be careful about dissing Suffolk County.
No, I thought it was very bold of him to do that. He slapped the governor down. He slapped down, basically his boss, right, the top judge in the state court system. So, I don't know how that will be resolved, but. That was
just you have an opportunity, if they don't care at all about being reversed or getting press or whatever it is, to state their opinion, and he certainly stated his opinion unequivocally.
So what would you do? I know some of these cases seem ridiculous. The Gap argued that, it has a lease in FIDI in the financial district that runs through 2030. It owes $60 million on that lease. So there's a lot of money at stake. And it's basically saying there's no foot traffic in the financial district. And by the way, internet shopping has kind of eroded the need for a brick and mortar store. So we should be able to get out of our lease. You're saying you wouldn't take a client who makes that argument?
No, I would. I mean, not if there wasn't anything in the lease that entitled you to say that.
What if they paid you gobs of money? Wouldn't you take the case then and just make it? Because someone is making that.
By the way, the other thing you have to think about is if you make an argument that has no basis to it, then all the other people that you represent on the other side that are watching you make that argument can be a little challenging. So even if they're paying you gobs of money, there could be some challenges that come out of that. So I think all Louise is saying is if there's a legitimate basis for making a claim, I mean, it's no different. We represent both borrowers and lenders. It's rare that we'll take a borrower litigation to sue a lender because most of those litigations have no basis to it. There's a circumstance now where there's actually, I think, a significant basis for it. So I think, for example, at our firm, you'd have to go and you'd have to get approval from the committee before you could ever bring an action like that. So you'd have to be 100% sure that you really had the basis for that kind of claim, because there are so many spurious claims that are made. And I think what Louise is saying, a lot of the defenses that are made in these, rental recovery actions, somebody dispossess actions are the same. Right? There's no basis for it. So someone throws a bunch of excrement against the wall to say, well, here are the 18 arguments I can make about why I shouldn't pay rent.
Right.
Well,
And by the way, gobs of money or not, Eric, the reality is attorneys do actually have ethical obligations not to bring frivolous cases, which is
and
not
can be
to say,
sanctioned.
look,
and can be sanctioned.
Exactly correct. Exactly correct. And it's not to say that making a creative argument sometimes that someone else thinks is ludicrous doesn't sometimes win and give you the leverage that you need to resolve whatever conflict you are in. But that said, you still have an obligation to not argue things that you know are really unfounded and not based in law.
Are you ever at risk for paying the other side's legal costs if you bring a frivolous case?
Well, it's interesting that you say that. In commercial leasing, there's always a clause with respect to attorney's fees. The only question is whether or not the tenant had enough bargaining power to make it reciprocal in the event of a default issue or a claim between the parties. If not, and it's a standard lease, it's more likely that if somebody hasn't negotiated for it, that the attorney's fees will go to the owner as the prevailing party, not to the tenant. And that the tenant will end up obligated to the owners for the owner's fees if they haven't carved that out in their agreement.
And then obviously only if the owner is successful.
That's what I said, prevailing. But here's the thing, sometimes in these cases, it can actually turn out that the legal fees could be as much as what's at issue in the dispute. And some cases at the end of the day have a lot of difficulty resolving just because of the issue of how much money has been spent in fees. So again, you try not to bring, you really don't want to ever bring a frivolous case, and you try not to make arguments that you don't think are founded, because there's serious consequences for doing it. And none of them end up well for an attorney.
I'm frankly.
And I would say that one of the things that we really haven't focused on, but is clearly the case, is not only are there potential litigations, but a lot of these things are just settled, right? And there are a lot of cases where the tenant comes in and says, my business is really being adversely affected. Take the restaurant. My business is being adversely affected. I can't function the way I function. So what I'd like to do is take my rent for this 6-month period and accrue it and pay it back over the next 2 years when the world opens back up again. And I think you're seeing a lot of that. A lot of work is being done with, negotiated resolutions between landlords and tenants, because, it's one thing if you're, Apple and you've got a huge balance sheet, you can pay the rent. Yeah. But if you're a restaurant tenant and your income walks in every day, orders lunch and dinner and then walks out. If they're not ordering lunch and dinner, then you have no revenue stream in which to pay rent. And so the landlord is making a sensible decision that says, look, in this circumstance, what I really want to do is preserve my tenancy. So I'm going to make a deal with the tenant that allows them to continue to function in this limited environment. And then when the world comes back to some sense of normalcy, then I'll be able to recover some of the money that I kind of forbore on for a period of time. And there's plenty of that.
So in many cases, you know, the legal leverage is on the landlord side because, you know, he's got this contract, which spells out exactly what he's entitled to. But in terms of the real world, you know, it's not that easy to replace a tenant at this point. So if he were to get rid of a tenant and try to bring in a rent paying tenant, he might not be able to find one. So that gives some leverage to the other side as well.
Exactly John's point. And I think that it's, you know, it's actually what's happened over the last number of months in that there hasn't been a court system. People have had to actually try to work things out on their own. Many have not. But, you know, we're talking a lot about the leasing context, and it's obviously a very important issue as to what's going on. But, you know, it's happening on the transactional end too. I've seen one client came into me and said, I don't want to do this deal anymore. I don't feel comfortable going forward. What's my basis to get out of this contract? That becomes problematic. Is there a basis, you know? And I've already been on the receiving end of something where someone filed a complaint saying they don't want to go forward with the deal because they're claiming breach on my client who's the seller, which we don't think there's any validity to it. But again, if you don't, or not, you know, maybe they think they have a shred of something they can argue, so they think they have a good faith basis to go forward. But I think it's just negotiating.
I'm wondering,
and I think Louise is talking about what happens, which is there may be a business basis for saying, I don't want to go forward with a deal anymore. And then people turn to the lawyers and say, okay, find me something in the agreement that allows me to walk away, right? It's not, I'm walking away because of paragraph 3. I'm walking away because the deal doesn't make any sense to me anymore. Now find me something where I have the legal right to walk away because that's the result that I want.
Exactly right.
You do have to find something, right? Regardless of what your actual reason is. I wonder if you could tell me, you know, you mentioned the courts are not really functioning. Like, what is happening now? I mean, you can get something done, can you not, in court in commercial real estate?
It depends what the something is. I mean, you know,
Something really important.
it depends what the something is. I mean, federal courts are open, the bankruptcy courts are open, state court is now open, although it's difficult to get into the court. It seems like everything's just a little off, you know. And
what about the moratoriums? What about the moratoriums? Like, there's a moratorium. Actually, most of the press has been about residential eviction moratoriums, but you can't evict a commercial tenant either, right? Until August 20th?
That's exactly correct. In fact, the most recent executive order that the governor signed, he only extended it as to commercial because he had already signed the Tenant Safe Harbor Act with respect to residential tenants, which he therefore felt he didn't need to continue to
protect
in the executive order. So, but it's interesting, there's all these overlays of different laws and dates they're expiring, and then they're extended or they're not, and everyone's waiting for the next, you know, what's the next installment? What's going to happen next?
How much time have you spent reading executive orders and laws over the last 2 months?
A lot.
Everybody's tracking them and then trying to inform their client base about what the most recent executive order or city council resolution, whatever it is that's now changing what the rules of the road are in terms of how their people should operate. So
if nothing happens,
that's a full-time occupation.
Right. So what happens on August 20th then, assuming no more executive orders? You're gonna go crazy? Do you run to court and just file a million things?
By the way, you could go to, if it wasn't extended, you'd go to court and then you wait online for all of the backlog of all the cases that haven't been able to be filed for the months and months. So I think you're going to see the backlog in courts be overwhelming for a period of time.
Well, there was this big concern that the landlord tenant court was going to be deluged with all kinds of cases. and everyone was going to be evicted. And none of that as a prediction came true, in large part because of the patchwork of laws and statutes and directives and executive orders that all exist. And I think there was a case recently where a law firm was, I'm not naming the firm, but they were sanctioned for having brought cases and serving pleadings during this period of time. I don't think anybody wants to be in that position, that they have run afoul. I think the Attorney General actually was looking into it and prosecuted it. So that's not pretty. And again, nobody wants to be in that position. So when you look at all these laws together and you try to figure out, okay, where do I come in, or where do we have an opportunity to come in? And there are some, there's actions against guarantors, which are corporate guarantors, not personal guarantors. And you can bring an action that there's a breach of contract, even if you're not, bringing a proceeding to try to take back possession. You can still get an adjudication that the tenant is in default and that they owe you X amount of money. You may not decide to bring that in L&T court right now as a result of the various laws that are overlaying people's concerns about their practice. But there are still things that you can do. And certainly, there's substantial letters of credit that exist, et cetera, et cetera. So there are some remedies that owners have, but it's a difficult time with all of these statutes. And you've got something expiring August 20th and something else expiring September something. And, people are trying to.
And then you have a lot of these ones where the law extends something for a period of months, like 6 months after the state of emergency. Well, we don't know when the state of emergency is going to end.
Right. Phase, which phase is it, right? That was a big discussion with the safe harbor.
And then one of these laws, and I can't believe how sloppy some of this legislation is. One of them says basically, as long as there's any restriction anywhere in New York State, we'll tack on 6 months to that. Well, when are movie theaters going to be open? I mean, when's Broadway going to be open? That could be a year.
When is Madison Square Garden going to be open, John? Any
By the way,
prediction?
That could have nothing to do with your client.
it also has to do with City Field and Yankee Stadium. I mean, I think we have, lots of challenges. I think that we're kind of working through it each time. I think New York has done actually a pretty good job in the scheme of things in terms of, how it's flattened the curve and managed to bring the caseload down. And I think, reopening in a sensible way. I think we've seen other states that have greater challenges in terms of reopening quickly and perhaps with not necessary protocols in place, and then suffering with the results from that. So, no one has a crystal ball as to exactly the right way to do it, but it does seem that we're making progress in terms of reopening, but reopening in a way that's, protecting the population at large and protecting New Yorkers as a whole.
So here's another question. Like, I fully expected a lot of landlords to sue tenants who are not paying rent, but I've seen a number of cases where the tenant who's not paying rent sues the landlord. What advantage do you have of suing first?
I think that was in a circumstance, particularly if somebody has a long-term lease and what they'd like to do is get out of it. The notion of bringing a claim based on impossibility or frustration of purpose, kind of bringing the landlord to the table. Obviously, you're going to assess the likelihood of success on the merits in that. I wouldn't be wanting to get a temporary restraining order on something like that. But I think you've seen some of those cases where people have said that by virtue of the challenges they may have been facing otherwise, having nothing to do with the pandemic, that their lease may be at levels that they can't sustain. So this may be a Hail Mary that allows them to, at least put forward an argument that says, well, I don't really have to pay the lease anymore because of these, legal precepts, which I'm trying to bend to apply to my situation.
Right. Luis, does that give you some bargaining power if you bring the case first and then sit down to negotiate?
Well, look, certainly, there's different ways of going about things. As a, general rule, I think that, move-ants have the ability to steer the course. If you have a basis to go into federal court and you move, and you have diversity and reasons to be there, you could choose to be in that forum, for example, as opposed to being in state court.
can
And so,
pick your
yeah,
venues, yeah.
it gives you certain benefits in terms of being the party that initiated the case.
Mhm.
And to put your complaint out there first, right? As opposed to being on the defensive and being sued, you're saying, hey, affirmatively, this is what I think. But as John said, and we talked about this a little bit, okay, do I have a basis to be able to do this? I don't want to go through with this deal, or I want to get out of this deal, please look at my
Mhm.
contract, lease, whatever the document is, and find me a way out.
Mhm.
And if you don't find a way out within the four corners of the document, then you start looking for common law doctrines, like what we're talking about, to try to find a basis to say, yeah, but just as a matter of, public policy and fairness, I shouldn't have to pay for this, right?
So I have one question. I have one question from a viewer who asks, what if owners want to impose health or safety regulations in a building? Can a tenant then come forward and say this is a material change in building services?
Generally, the landlords have the right under their leases to impose reasonable rules and regulations. I think in the current circumstances where we're in the midst of a pandemic, and there have been government guidelines about things that people should be doing with respect to their buildings, whether that's hand sanitizer in the lobby, access to the elevators without necessarily having to transfer IT back and forth. So I think those protocols have been recommended protocols which have been put forward by the government. Obviously, if you do something that's consistent with a government recommended guideline, it's very hard for a tenant to argue that that is somehow a breach of their lease. And given the broad nature of the regulatory power that the landlords have under most leases, I would think that's probably a hard road to hoe.
Mhm. So I don't know how many new lease negotiations you've dealt with since the pandemic began, but I would imagine that there's going to be a clause in every single lease now. What kind of clauses do you think will become standard now, in commercial leases going forward?
I think it's hard to say that there will be a standard going forward. I think a lot will depend on the leverage of the parties. It's very hard. I mean, I think the construction is likely to be addressed, so that if a landlord is doing work or a tenant's doing work and they're delayed by, a pandemic kind of circumstance or a stay-at-home circumstance or a pause on construction, I think those are likely to give some relief in terms of the postponement of rent commencement dates by virtue of, in effect, a force majeure event. I think the one that's much more difficult is to have the pandemic concept incorporated into the cessation of services provision, which would allow for a rent abatement, because I think that's very difficult to finance. So I think that's going to be on a case-by-case basis and really going to be the subject of who's got the negotiating leverage and how important it is for the landlord to have that tenant in the building or the tenant to have that space. And I think we will all be better off if we can find some government-sponsored resolution that is akin to TRIA, but for the pandemic, because there's no easy solution otherwise.
Mhm. What can I ask you both? What kinds of mistakes do you see commercial real estate players make that end up in the lawyers having to resolve? Like, do you see fairly common mistakes happen again and again, or even uncommon ones that end up having to be resolved in court?
Okay, can I use an anecdote for this? I saw recently a cartoon where somebody was giving their dog a biscuit or something, and they said, okay, talk, speak, and the little bubble was not without my attorney.
Right.
And it's like that. It's like, you know my phone number, you know how to text me, you've done it a million times. Check in before you say something that then you're trying to back out of. Just ask the question. You had that experience, John, where it's just, why didn't you call me before you did X, Y, Z? You know, before
Yeah,
you wrote this letter.
I would say there's sometimes people sign things that they should never have signed. So hopefully you're doing those things with the guidance of a lawyer. Sometimes, obviously, in hindsight, everybody is a genius. And so things that people didn't anticipate, they come to fruition. Oh, how did you not protect me for that? Well, it's not normal to protect you for that. I think, in the leasing context, one of the things, the most common things that I've seen is with respect to subleasing rates. I think that people don't necessarily, large commercial tenants always pay attention to it, but smaller tenants and less sophisticated tenants don't necessarily pay attention to, what that really means and how they're going to extricate themselves from leases where their business models change and they no longer can occupy the space. So always thinking about the exit strategy and how you're going to exit from what you're doing, whether that's early termination options, whether it's contraction options, whether it's having broad sublease rights and not being tied up in knots so that you can't really get out. And then you just end up paying the owner, a significant sum of money to be able to exit your lease. So I think all these things, when someone says something's boilerplate, that just means that it's been printed up in a way that looks like it's the way it always is, and it never is. It's only that way if somebody writes it that way. And so you really need to pay attention and make sure that what you're doing makes sense in the circumstance that you're doing it in.
We only have time for one more question. This is another sort of layman's question, and I'm going to direct this to you, Luis. So I didn't go to law school, but I seem to remember that, a handshake is not an enforceable contract. I know people talk about handshake deals. That's not an enforceable contract. But if you say something and it entails, a promise that lasts for a year or more, that's an enforceable oral contract. Could you just briefly explain to me, like, what kinds of things happen, outside the presence of lawyers and stacks of papers and notaries and documents that end up, being enforceable contracts that can lead you with some obligation you don't want?
Well, it's interesting that you say that. Typically, you need a contract for a writing in order to be entitled to relief, to be able to rely upon whatever agreement existed. There's a good reason for that. And there's a statute that relates to that and says, no, you can't have that happen. But there are instances where, notwithstanding the fact that there isn't a writing, somebody could try to make the argument, and I'm in one
And has.
I'm dealing with one right now where a seller had seller's remorse after selling his property and went into a whole litigation with us about why we breached an oral agreement where he would have an ownership interest and participation in the property after he sold it. So, people make these things up because they just decide after the fact that, and now he's trying to create a case. He's trying.
But there is such a thing as an oral contract, though, correct?
The courts really frown on it.
And there are limitations. They can't be above a certain amount of money. They can't have a duration of longer than a year. So that's the statute of frauds that Louise was talking about. So yes, there can be an oral agreement, but there are limitations, and they tend to be smaller agreements and for shorter periods of time. The one last thing I would say is where people get themselves in trouble is that there's things that are used that's known as a letter of intent. And I can tell this because I just happened to me within the last 2 days. Someone on a piece of property worth more than $100 million, the potential buyer wrote a piece of paper that said at a very, very favorable price, big price, and wrote a binding letter of intent pursuant to which the seller would be obligated to sell them the building for more than $100 million. They, of course, didn't subject to due diligence. It was, so somebody sent it to me, I said, this is a recipe for that potential buyer jerking you around for the next several years at no cost to themselves. Why in the world would you sign a piece of paper like this? Now, I'm just telling you that too many times people have signed pieces of paper, maybe not quite like that, but of that ilk. And that can be a nightmare. That can be a lawyer. So when they sign that piece of paper and then they call Louise and they say, Louise, this isn't binding on me, is it?
Oh, man. Well, we're,
And that's why I say, never write what you can say, never say what you can whisper.
all right, we're gonna have to end on that note. I want to thank Luis Barak of Rosenberg and Estes and Jonathan Mechanic of Fried Frank. And before I forget, 1 week from today, our publisher is going to be hosting the next edition of TRD Talks Live about PPP, Paycheck Protection Program, which is basically the lifeblood of American business at the moment. So please tune in for that. You can register at therealdeal.com. Thanks again to our guests, and we'll see you next time.
Thank you, John.
Thank you so much.
Eric.
Thanks so much. Thanks, Louise.
Bye all.
Bye.